Opposing counsel just cited a case that does not exist. The fine for missing it isn't on them, it's on you. In the next 10 minutes, I'll show you the 3 signals that flag fabricated material in seconds, the verification sequence I run before I touch the merits, and the 3 moves you can make once you find one. Ever since AI went mainstream around 2022, attorneys have been using AI across every stage of their legal work. The problem was never that they were using it. The problem is that hallucinated garbage has been making its way into court filings. Every CLE on this topic is teaching half the equation. Do not be the lawyer who gets sanctioned for citing a fake case. Fine advice, it is also the floor. The other half is this. Opposing counsel is filing briefs against you right now with hallucinated citations buried in them. A few you will only catch by accident. Most will get past you, and a court that rules against your clients based on a fake case is a problem that you owned the moment you read the brief and missed it. This video is about that half. There are 3 tells that should make you stop and verify before you read another sentence. After a few months of training your eye, you will spot them in seconds. Signal 1, reporter format inconsistencies. The case name reads fine, the volume number reads fine, the reporter abbreviation does not match the court that supposedly decided it, or the page number falls outside the range that reporter actually publishes, or the year inside the parenthetical is impossible given when the volume came out. Hallucinations assemble citations from the right places in the wrong combination. A real cite has internal consistency across all 4 fields. A generated one rarely does. Signal 2, holdings that are suspiciously on point for the proposition cited. Real cases are messy. They turn on procedural posture, on the specific record, on facts that do not map cleanly onto your dispute. We all know this. We've all dealt with it. A citation that delivers exactly the rule opposing counsel needs. In one clean sentence with no qualifier and no procedural carve-out is a citation worth verifying. Real law rarely lines up that neatly. Generated law lines up that neatly almost every single time. Signal 3. Generic or vaguely plausible case names that do not appear in the citing court's controlling authority. Smith v. Johnson, In re Anderson, United States v. Williams, with a circuit and year you cannot quickly place. The name is bland enough that you do not recognize it. The citation looks federal, the proposition supports a key piece of opposing counsel's argument. Pull it. A generated case name has to plausibly exist without colliding with one you would recognize, so it lands in the most generic possible territory. 3 signals: inconsistency, suspicious precision, generic name. None of them is conclusive on its own. All of them are reasons to stop reading and verify. The skill is not shepherdizing every cite the way you did in your 2nd year of law school. The skill is triage. Here's the sequence I run. First pass. You read opposing counsel's brief once through, the way you would read any brief. As you read, you mark suspicious citations in the margin. Not verified, not run, just flagged. Anything that hits one of the 3 signals gets a check mark. Keep moving, do not break flow. Second pass, you batch. You take the flag citations and you run them in a single sitting against a primary source database. Westlaw, Lexis, Bloomberg Law, Pacer for recent district court material. Verification is faster when you are doing nothing else but reviewing the cases, and slower when you are interweaving it with the substantive read. Critical rule: you do not verify a citation by asking the AI tool that may have generated it. This is a major red flag and you should never do it. You do not type the cite into ChatGPT or Claude or any other model and ask whether the case exists. Models will confidently confirm cases that do not exist because confirming is what they were trained to do when prompted that way. Verify against a database that indexes published opinions or against the court's docket directly. Then there's the harder, more crucial problem most people miss. The case exists, meaning the case name is real, and the holding exists, but the holding is absolutely wrong. This is the more common failure now, and it is the one that catches experienced lawyers off guard. You pull the citation, it loads in Westlaw, you check the box, and move on. Stop. read the headnote, read the section of the opinion the proposition is being pulled from. Generated briefs misquote real cases constantly. Sometimes they invert the holding. Sometimes they cite dicta as the rule. Sometimes they pull a proposition from the losing argument. Read the case, not the headnote, not the cite, the case. You found one. Now the question is what to do with it. There are 3 moves on the board, and the right one depends on 3 things: the stage of the litigation, the strength of your underlying position, and whether the fabricated citation is load-bearing in opposing counsel's argument. Move 1. Raise it directly with opposing counsel before you file. You email or call, you point to the citation, you ask them to withdraw and refile. Lowest tactical value, highest relationship value. You preserve cordial dealings. You also hand them a chance to fix the brief before the court sees the error, which on a close motion is the chance you do not want to give. Use this move when the underlying motion is not close, when an ongoing relationship matters, or when an ethical concern requires you to act regardless of tactical cost. The one thing I will mention for this, as all of you know, is that you must check your bar association's ethical rules to make sure you are in compliance with the court rules before doing anything like this. Move 2. Drop it in a footnote in your reply brief. Cite the bad cite. Note the case does not stand for the proposition advanced or does not exist. Move on. The footnote signals to the court without making the brief about opposing counsel's conduct. This is the workhorse move. It captures most of the tactical value without forcing the judge to choose between substance and sanctions. Move 3, save it for oral argument. Let the judge discover it in real time or position your argument so that opposing counsel has to defend the citation under questioning. Highest tactical value, highest risk. If the judge has already relied on the citation, you look like you sandbagged. If the judge catches it cold, opposing counsel takes the credibility hit in front of the bench, and that hit carries through every subsequent ruling in the case. The last thing I will mention is, in some jurisdictions like New York, there is a duty to report as soon as you know opposing counsel did something unethical. Again, you must make sure you're always in compliance with ethical rules whenever filing anything with the court. 3 moves: raise it, footnote it, hold it. None is automatic. Pick the one that matches the moment. One more thing, and it is the reason this skill is not optional. Model Rule 3.3 obligates candor to the tribunal. The duty runs to you, not just to opposing counsel. If you read a brief, you spot a fabricated citation, you understand it's fabricated, and you stay silent while the court relies on it in a ruling that benefits your client, you have a major problem. The ABA in 2024 finally gave us an opinion on generative AI and lawyer ethics. I'll paste a link to that opinion in the description below. Rule 1.1 already includes the technology competence comment. Rule 8.4 covers misconduct generally. Rule 11 of the Federal Rules of Civil Procedure provides the sanctions framework on the federal side under both 11B and 11C. Stack those obligations. The lawyer who cannot spot a hallucinated citation is not just losing motions, and this is important. That lawyer is exposed under Rule 1.1 for failing to keep up with technology, exposed under Rule 3.3 if a fake cite goes uncorrected on their watch, and exposed under Rule 11 for representations that ride on it. The offensive skill and the ethical floor are the same skill. The lawyer who builds it wins motions and protects their license. The lawyer who does not is exposed on both ends. That is the trade. There is no version where you opt out. If you want the deeper analysis of how Rule 3.3 interacts with the ABA's formal opinion on generative AI, including the harder questions of what you owe when the fake site helps your client, I wrote it up on Substack, and I'm going to put a link in the description below. Subscribe here for more practitioner-specific content on AI and the practice of law. One thing to take from this video: catching a hallucinated citation is not defensive hygiene anymore. It is an offensive skill. The lawyers who build it are going to win motions their colleagues lose, and they are going to do it inside the same ethical rules that catch their colleagues going the other way. Every brief you read from here on out, you're either the lawyer who catches it or the lawyer who doesn't.